Chapter 7. Courts of the Commissaries for the Archdeaconries. The bishop, by patent, appoints a commissary for each archdeaconry in his diocese, and such commissary is the bishop's representative within the archdeaconry, and amongst other things, exercises testamentary jurisdiction. At the passing of the Act of 24 Hen. 8. The commissaries were appointed during the pleasure of the bishop, but they now receive their appointments for their lives. But although the commissary represents the bishop, yet as the jurisdictions of the dean and chapter and prebendaries are exempt from the archdeacon, and consequently do not form part of the archdeaconry within which they are situated, the jurisdiction of the commissary cannot extend over them, for it only extends over the same parishes and places as the jurisdiction of the archdeacon. In the case of the king against W. Younge, D.D., the court decided that the appointment of the bishop, as it regards the power of the commissary to prove wills, arms him with episcopal authority for that purpose. The grant of the power attracts to it all the means by which that power can be exercised. The commissary is bishop for the purpose of proving such wills, as he is authorized by the grant to prove. It is difficult to understand the case, but as the authority of the commissary extends only over the archdeaconry, it can only have been decided that he had episcopal authority over such archdeaconry, and the return to the mandamus issued in this case having stated that the probate was as valid in law, as if it had been granted by the vicar general, in the said consistorial or episcopal court, and that the court of the archdeaconry of Sudbury had possession of the original will, and denied that the defendant had authority to issue a monition, the confirmation of the return by the court could be considered only as deciding that the probate was valid, and that the defendants had no right to issue a monition. The commissary is inhibited from exercising jurisdiction, for 3 months, once in 3 years, at the time of the bishop's primary and triennial visitations, and his jurisdiction is, consequently, subordinate to the bishop. See Bear and Biles v. Jacob, 2 Haggard's Reports, 263. The commissary, mentioned in the statute of 24H. 8. C. 5, must have been intended for the bishop's vicar general and official principal, or chancellor, and not for his commissaries in the archdeaconries, for the vicar general and official principal was formally appointed by the bishop, to supply his place in his diocesan court, when urgent business required his absence from his diocese, and consequently the acts speeded in the diocesan court must have had the same effect, whether the bishop himself or his vicar general and official principal presided. If the appeal be from the bishop to the archbishop, the appeal from the vicar general and official principal must necessarily be the same, and this must have been the view taken by the framers of the statute, for it speaks of the bishop or his commissary, as of persons, that, at different times, presided over the same court, in the same manner as it mentions the archdeacon or his official. If the statute had intended the word commissary to comprehend the commissaries of the archdeaconries, the conjunction would have been copulative, as comprehending the courts of the commissaries as well as that of the bishop, and not disjunctive, for the commissaries of the archdeaconries were appointed to hold their courts within those archdeaconries, because the bishop himself could not conveniently hold his diocesan court there. It is laid down by Sir John Nicol, in the case of Parham and Templar, that the visitation and appeal necessarily go together. Now, as the commissaries of the archdeaconries are the mere delegates of the bishop, as their jurisdictions are periodically inhibited by him for 3 months once in 3 years, and as during such inhibition the bishop not only visits all the districts comprised within the jurisdiction of the commissaries, but his chancellor exercises all ecclesiastical jurisdiction within such districts during the inhibition, the jurisdiction of the commissaries must be subordinate to the bishop, and being so, the appeal from the commissaries must be to the bishop, as to their immediate superior. If the word commissary in the statute is considered as applicable only to the bishop's chancellor, all the jurisdictions are clear and intelligible, but if it is construed to comprise the commissaries of the archdeaconries, then the various jurisdictions of the diocese become confused, and irreconcilable with the principles laid down as regulating them. And that the commissary mentioned in the statute must have been the chancellor of the bishop, is to be collected from the ancient practice as laid down in Linwood, where, after mentioning the vicar general and official principal of the bishop, it is said, I estimate differently the officials for foreign parts, officials for ansi episcoporum. Nor does it make any difference if they say that they have jurisdiction in all causes, inasmuch as they have not general jurisdiction with the bishop, but particularly in a certain district, or in a certain place belonging to the jurisdiction of the bishop, and such officials have not the same consistory with the bishop, but the appeal is from them to the bishop. And it is further said in Linwood, I ask in what these official principles differ from other judges deputed by the bishops. First, they have the same court of audience with the bishops, nor is the appeal from them to the bishops, but to those to whom the appeal is made from the bishops themselves. Nor yet is it so in others, who are not official principals, such as officials for foreign parts, who are deputed even for the decision of causes of all descriptions, in a certain part of a diocese. But from these others the appeal must be to the bishop himself. And they differ also in this, that the official principals are ordinaries, but the others are delegates. The same principles are laid down by Aleph. If it is said that the appeal from the commissaries of the archdeaconries has, according to the practice of late years, been to the archbishop, and not to the bishop, such practice has so obtained a footing in violation of the ancient laws and ancient practice regulating such appeals, and in opposition to the principles at present laid down for ascertaining to whom an appeal should be made. For if the visitation and appeal go together, the appeal from the commissaries of the archdeaconries in the diocese of Lincoln must be to the bishop, it being incontrovertibly clear that the bishop has always exercised, and still exercises his right of visitation in the commissaryships. The observations which, on treating of the jurisdiction of the dean and chapter and prebendaries, were made in respect of the jurisdiction of the prerogative court, are applicable to the jurisdiction of the commissaries, with this addition, that there can be no pretence for giving to the jurisdictions of the commissaries, either the name or title of peculiars and exempt jurisdictions, or, consequently, for considering them to be subject to the jurisdiction of the prerogative court, except as part of the diocese. For if on a person's dying, or leaving bona notabilia in any such jurisdiction, and leaving bona notabilia or dying in another part of the same diocese, the probate or administration should be deemed to belong to the prerogative court, these jurisdictions must be considered to be distinct from the diocese, and exempt from the jurisdiction of the bishop. Where then would be the diocese, if all the commissaryships were to be so considered? And it would lead to this absurdity, that the commissaryships of the archdeaconries would be exempt from the bishop, whilst the jurisdictions of the archdeacons, which extend over the same parishes and places, as the jurisdictions of the commissaries, would not be exempt from the bishop.